Welcome to the Probate Nation. I am Richard Ruddy, the host of the show. Our show tonight is about dealing with investment accounts in the course of probate. There are important details to keep in mind, steps to take, and pitfalls to avoid as you undertake to probate this asset, which leads me to share a story of a defendant who was not happy with how things were going with his court case in court. So he proceeded to give the judge a hard time, and the following exchange between the judge and the defendant unfolded. The judge says, "Where do you work, defendant?" And the defendant responded, "Here and there." The judge said, "Well, what do you do for a living?" And the response was this and that. Having heard enough, a very patient judge then rules, "Take him away." And the defendant said, "Wait a second, when will I get out?" And the judge said, "Sooner or later." For many reasons, including your personal liability as a fiduciary, probating an investment account is something you should get to sooner, not later. To help you do so sooner, we are pleased to have with us tonight an experienced financial advisor. He will walk us through what an executor needs to do to deal with investment accounts in the name of the decedent, including some specific situations he often encounters. But let me tell you a little bit about our guest. He grew up on a horse farm in Marshall, Virginia, graduated from George Mason in 2006, and became a financial advisor in 2008. Shortly thereafter, he joined his business partner, Pat DeBurn, in the Leesburg, Virginia office of Merrill Lynch Wealth Management. His practice focus is to develop and service financial plans for individuals and business owners. He's a certified financial planner, but when not working, he and his wife are busy raising or chasing, as the case may be, their active 3-year-old son, Mason. Please welcome Stephen Gray from Merrill Lynch Wealth Management. Stephen, thanks for coming on the show today.
Thank you, Richard, for having me.
So let's begin with we'll start with the very basics. Explain how investment accounts might be titled.
Well, investment accounts can be titled in many different ways. Some of the most common ways we see them are individual name. We see them joint with rights of survivorship. And we also see them in revocable trusts.
Okay. So, I think part of what we see often is, what does the TOD or POD mean, and can investment accounts have such designations attached to them?
TOD and POD mean basically the same thing. It's either transfer on death or pass on death. What that generally means is the accounts then become titled more like an IRA or a life insurance policy, where they're left to a designated beneficiary. And yes, investment accounts can have those. That's
good. Now, can this titling of an account with another, or with the POD or TOD designation, can that cause prevent the executor from having any control over that account?
Absolutely, because when it's POD or TOD, it transfers directly to a beneficiary, which means the account does not go through probate, and so the executor wouldn't be involved at all.
Now, can someone normally tell how the account is titled or whether it has a POD designation by simply looking at the statement from the brokerage house?
Sometimes it's difficult, depending on where you're at. In Merrill Lynch, where I work, yes, we do have that in our stencil. So you would look at the statement and you would see that designation directly there.
Okay.
Other times you might need to call.
Okay. Now, let's kind of switch gears for a second and talk about some tax considerations. So, are there any tax considerations that should be addressed with assets in an investment account after somebody has died?
Absolutely. There's big tax incentives and big things you do with an account when somebody passes away. One of the main things is you have to step up the cost basis to the current fair market value based on the date of death for the decedent.
Yeah, that's very, very important. Now, how would I be able to tell if that's been done, though? In other words, if I pull up the bank statement, broker statement, a couple months after someone's passed away, how would I be able to tell if that had been done just by looking at the statement? Or can I tell it?
Yeah, you can actually now. They have changed rules that makes statements have that information right on them. You would look at the statement and see when the actual cost basis date was. And you would look to see if it matches the date of death for the decedent. And if it does, then you know that those cost bases have been updated to fair market value.
Sure. Well, I think that's really helpful. Does the brokerage house normally automatically update the cost basis of those assets that are held at that brokerage house?
No, they won't automatically do it. They'll wait for instructions from the executor to update those cost bases. So it's probably a good idea to double check that they've been done or call and make sure with the brokerage firm that it has been done.
Yeah, so the concern and the reason that this is important and why we bring it up right away is that if they become executor and they proceed to go ahead and sell some assets, if the cost basis hasn't been updated, then they may end up having some sort of gain that then gets reported to the IRS when in fact there would be no gain because the cost bases have been increased. So very important to get that done early on. Well, let's talk a little bit about the investment titling of investment accounts, how they have an important estate consequence. Tell me how they can help a estate plan or how they can wreck an estate plan.
Well, titling is very important depending on whether things are going to go through probate, pass directly to a beneficiary, or be titled in the name of a trust. So it's very important to have the titles correct the way your estate plan is set up to make sure that everything goes through smooth. Otherwise, you can have part of your account that's going to go non-probate and some of it's going to be probated.
I think you make a good point. So if something is in the sole name of a decedent with no beneficiary designation, no TOD, then that asset's going to go through probate, and then either the decedent's will is going to govern where it goes or the laws of intestate succession will take over. If you have a POD or TOD, it might very well be that you have a will, but that POD, TOD designation may be inconsistent with your plans as set forth in your will. What problems do you see arising from the use of the TOD and POD designation on investment accounts?
Well, you see the same problems with a lot of things is people don't keep up with those designations. So either they've named the wrong person, they've had some kind of family issue where they're no longer with somebody and they needed to change that a while ago, and they just haven't done it. So that's generally the main thing.
Yes, it is true. If I have an investment account, can I do a TOD or POD to my revocable trust?
Absolutely. You can do a TOD or a POD to a trust, to an individual.
That's important, and that's helpful because that avoids the probate on that asset.
That's
Well,
right.
let's talk a bit about a couple of different scenarios where we have to open up an investment account. So what kind of documentation is needed to transfer the decedent's investment account into his estate? It's in the decedent's sole name. What do I have to do in order to set up an account to transfer that into the estate of the decedent?
Well, the executor first has to be named, so they're going to have to provide documentation showing that they're the executor on the account.
Mm-hmm.
They'll need to get a new tax ID number for the account.
Mm-hmm.
They'll need to provide us with a death certificate. They'll have to provide us with a new account application to open an estate account. And then also a letter of authorization from the executor having us move those funds from the decedent's account into the estate account.
Now, because everybody's a little bit different on how they handle this, but does that all have to be done in person or can it be done by fax or email?
So most of it can be done by fax or email. If we do need something that's notarized or needs to have a raised seal, we tend to like to have those things in wet form.
Okay. Now, how long does it typically take to process the paperwork to get the estate account established and then funded with the decedent's account closed?
Well, the hardest thing is for the person to get all the documentation together. Once they actually get it to us, roughly 2 to 3 business days.
Okay, that's pretty quick. Let's talk a little bit about the next sort of scenario is, let's say I have a trust that needs to open up an investment account, and we want to transfer the estate investment account now into the decedent's trust. Okay, so we have typically that's going to be a pour over will that says whatever I have goes over to my trust. Okay, so what kind of documentation are we going to need to give you guys in order to get that trust account set up?
Well, in that case, the estate account's already opened. So the next thing to do is open up a new trust account. So we would need a new trustee certification form. We would need a new account application form, and we would need a letter of authorization coming from the executor telling us to move the funds to the trust.
Okay. Now, the certification of trust, typically when people do estate planning documents that involve a revocable trust, that there is a certificate of trust that's created to give some of the basic information that banks and brokerage houses want to see. Is that something that you're talking about, that's what you'd be looking for?
That's what we'd be looking for, yes. We would also fill out a Merrill Lynch certificate of trust form and have them sign and notarize that as well. But that information comes directly from the trust that you're mentioning.
Okay, so you still need to fill out a certificate of trust form for your shop as well. Okay.
Yes.
Now, can all this work to get the trust investment account set up? Can that be accomplished by fax or email, or again, does that need to be done in person?
That can all be done by fax or email.
Okay, and that's because we've gotten past, we know that person has passed away, and as long as we have, now, people have to understand you're gonna need a tax ID number for the trust. That's gonna be different than the tax ID number for the estate, so people should be aware of that.
That's right, they're two separate entities.
Now, again, how long does it take for that paperwork to be processed to get that trust account set up?
About 2 or 3 days, sometimes longer. It just depends on, how busy we are here at Merrill Lynch.
Okay. All right, let's take a look at the next sort of scenario, which we talk about, which we kind of alluded to earlier in the show. What if I have an investment account that's been set up so that it automatically transfers from the decedent by way of a TOD designation to their revocable trust? What do I need in order to set up the investment account for the trust in that situation?
Well, we need all the paperwork we just talked about for the trust, because that's what the TOD is dictating to go to. So we need a new account application. We need a new trustee certification form. We'd need to have a letter of authorization again to move it from, actually the letter of authorization is there. We have it from the TOD. So that's a much more simpler, movement.
Now, will you need the death certificate in that situation?
No. Well, we do need the death certificate because there's a TOD, so we need to, make sure that that's on file to show that the person actually has passed away.
I was going to say that probably is important.
That is important.
Let's talk a little bit next about, again, can most of this stuff be done by fax in that scenario, or do we have to come in and see you guys?
So these days, most things can be done by fax and secure email.
Secure email, yes, of course. And the time period to turn that around remains to be 2 or 3 business days?
Yeah, I believe so.
Okay. So, as an executor and as a trustee, a lot of times myself, I may need to get back records in order to do tax returns or whatever the case may be, but the accounts are now closed. Okay, so after the decedent's investment account is closed, how do we go about, or can the executor or trustee get access to old records?
We can. I mean, we keep the records pretty much on file for the past 5 years.
Okay.
So we can go back that long. If we need to go back further, we can go back further. They're usually in our historical records department. It could take a little bit of extra time, but they do have access if they've established themselves as executor for that estate, and we can go back and pull those records for them.
Okay, that's very important. That's very important. So, obviously we want to try to avoid probate if we can. Sometimes it just turns out that people don't do the necessary steps, but there are most states, and certainly Virginia is no different, they have some special provisions for estates that have small asset values that allow them to be probated without going through the formal probate process. And that's commonly referred to as they can use what's called a small estate affidavit. Tell me a little bit about how you folks deal with small estate affidavits when someone presents those to you for an account that you guys have at your shop.
Well, they're going to go through our compliance department to make sure it's filled out correctly. We don't have any problem accepting small estate affidavits as long as they are filled out and notarized appropriately, and as long as they come from the correct state. So Virginia has small estate affidavits, some states don't, so we'd have to look at that and make sure that it's, the person passed away in the correct state and that small estate affidavit is filled out correctly.
Sure. And why are small estate affidavits typically rejected? Do you have any sort of sense of that?
They're rejected because someone didn't fill them out appropriately. Someone didn't get a letter from the heirs all signing off on it for distributing the assets with the small estate affidavit.
Mm-hmm. Yeah, the small estate affidavit does require everybody to kind of sign off. We identify who all those folks would otherwise inherit the asset.
Right. Sometimes having a will is helpful as well for Merrill Lynch to look at that and make sure that we're doing the appropriate thing.
True, and I think that's one of the things that's typically going to be stated in the affidavit: was there a will or not? So, and if there is, I can see why they would want to see that. If it's not, then they realize that intestate succession will take over. Right. So let's just talk about some sort of practical observations. Is an investment account, whether it's in an estate or in a trust, is it protected by FDIC insurance?
So not necessarily. So the cash inside of an investment account can be protected by FDIC insurance, but the investments are protected by something called SIPC insurance, which is something the brokerage firms use to insure themselves.
And what is SPIC supposed to insure against?
So it essentially insures against the brokerage firm going out of business.
Okay. Because most of the actual stock certificates themselves are not actually held by the brokerage firm, right? They're held in book entry someplace?
They're held in book entry someplace, so most of the time your assets are very safe and they're not going to go anywhere. But if a company does go out of business, you might lose access to that account for a period of time. So having that SIPC insurance allows people to have access to funds in the meantime.
That's very important. Now, you said that FDIC insurance would cover some things. I'm not sure. Is that just cash it covers?
So if a brokerage, if the account is holding cash in the account, which they tend to sometimes these days, those funds can be put into a money market fund that's FDIC insured.
Oh, I see. So, and is that a money market fund that some bank that Merrill Lynch knows or the brokerage house deals with?
Yeah, that's correct. We have many different avenues. We can essentially insure up to, I think it's $49 million with FDIC insurance by moving it between different banks.
Right, and I've actually had to do that in years past when things were looking bad.
Right.
Should the executor or the trustee, once they've got the investment account set up, should they order checks?
I think they should, unless they're planning on just holding that account with the investments in it. Sometimes people have a bank account that they're using to pay bills out of, but they can also use their investment account to pay bills just like a checking account.
Tell me a little bit about some of the challenges. I know you've been in the investment business for many years now. What are some of the things that you've come across that people do with investment accounts that as far as how they own them and title them, that causes the most grief for the family when they pass away?
Well, of course, the most important thing is making sure that those accounts are titled the way you want them titled. So typically someone will have titled something a long time ago and then forgotten all about that. And then they pass away unexpectedly, and those assets don't pass the way that the family thought that they should pass.
Okay. So
that's usually the most important thing that people have. Make sure that the records are correct.
And this came up in a situation this summer. If we have a TOD account that's payable to 3 children, will the brokerage house typically let any one of the 3 kids come and collect everything in the account, or will they divide it by 3?
They will divide it by 3.
They will.
They will. And you can designate further per stirpes or per capita on each of those beneficiaries so that you can designate in case one of those beneficiaries is predeceased, the decedent.
Okay. Yeah, it was just a little bit of a concern. I had a bank tell me that they had seen some banks where they just gave it to the first person that came in the way of a bank account that was TOD. So I'm going to have to investigate that.
That could cause some issues.
That would be a problem, and I think would upset some people.
I think it might.
So let's just go ahead and get some final thoughts, about some things that you want to share with our viewers about investment accounts, how they should be set up, issues you've seen, practical advice, some pitfalls to avoid. Just kind of take a few minutes to kind of flesh those out for us as we start to wrap up this particular program.
Well, personally, what I think is people need to keep good records. Make sure you know where all your documentation is. A lot of times when someone passes away, the children have no idea where those documents are. And I know I've seen some file folders that are full of files that are shoved in there from the 1970s, and they could take weeks and weeks and weeks to find those documents. The other thing is to make sure that if you have an estate plan, make sure that you keep it up. Make sure that you're looking at it yearly, bi-yearly. Make sure that the designations that you have for those accounts are properly put on those accounts, and that the people that are supposed to get the funds are appropriately designated in your accounts. I think some of those things are the main issues that I see going forward.
Certainly, all those things that you mentioned are things that are of concern to us. Certainly we have seen the benefit of collecting copies of every statement a client has for all the various accounts, so that when something does happen and the children, contact, us, that we're able to say, well, I'll set up a Dropbox account and here's every statement I know about. So they know where to go. I think the other thing to keep in mind too is making sure that the contact information for all those TOD beneficiaries remains current. A lot of times that changes, and we've seen, difficult challenges of trying to locate people all across Europe and Africa that we're supposed to get something, but you just can't find them, notwithstanding the best efforts. So keeping that up to date is very important. I think that advice is very critically important. Well, look, Stephen, I think that this has been very, very helpful. I want to thank you very much, Stephen Gray from the DeBurn and Gray group at Merrill Lynch, for taking the time to visit with us today, for sharing all this valuable information, and for your commitment and that of your firm to serving our community through public education programs such as this show. So again, thank you so very much, and please give my kind regards to your partner.
All right, thank you so much, Richard.
You're very welcome. Investment accounts are something we see regularly in probate, and often this asset is quite substantial. Whether the investment account needs to go through a formal probate or not is important to know. Hopefully, the decedent has done planning to avoid probate, but regardless, there is paperwork that should be filed without delay, so you gain the authority to deal with this asset sooner rather than later. Remember, assets go up and down in value, and you can find yourself responsible for losses incurred while you are executor if you do not act promptly. So get with a financial advisor as soon as possible to deal with the investment account. This concludes our show this evening. We hope you found it informative. Just a reminder that replays of this show can be viewed on the Probate Nation website and YouTube channel. And if you want to receive monthly estate administration and probate tips, please sign up for the free Probate Nation newsletter. Until next time, I am Richard Ruddy, and this is the Probate Nation.